Good morning, students. This is Suresh, your commerce teacher from Government Degree College, Kukatpalli. Today, we will learn the remedies for breach of contract. Friends, if contract is performed by all means by both the parties to it and formally discharged, there is no question of remedies arising for any aggrieved party. But when the contract is revoked, that means when one party breaches the contract or the obligations conferred to him by virtue of the contract, the other party shall be aggrieved, shall sustain some losses. Such parties should have some remedies in the eyes of law to make good the loss suffered by such aggrieved parties. Isn't it? The party not revoking the contract suffers a loss because of the revocation of contract. Such party shall have certain legal remedies. So, what are those legal remedies is our present topic. Friends, we can identify 5 legal remedies available to aggrieved parties in the case of breach of contract. Please do remember that these are only exhaustive but not conclusive. That means court can grant any number of remedies in any form if it deems fit to compensate the same to aggrieved party. I mean, these 5 remedies are not the only remedies available to aggrieved parties in the case of revocation of contract. So, what are those 5 first? But they are very famously exercised. So, we discuss the 5 major remedies. 1. Suit for rescission. Suit for damages. 3. Suit for quantum merit. Suit for specific performance, and suit for injunction. Let us see one by one. Suit for rescission, that is, filing a suit in the court to cancel the contract. What is this? When the other party is not willing to perform the contract, you need not to perform your obligations. The contract is said to be discharged. Section 51, isn't it? Then why the question or situation of filing suit to cancel the contract arises? Because sometimes contracts involve government agencies. Contract involves recollection or refund of caution deposits, right? So this type of contracts requires formal termination in order to absolve from the liability, especially when government agencies are there and government is not coming forward to formally discharge the contract, though it has committed revocation. Then you can go for court and file a suit for rescinding the contract, that is, cancelling the contract, right? Next, suit for damages. So there are 7 different types of damages identified by law. Let us discuss one by one in detail. Right. The first one is ordinary damage. Second one is special damage. Let us understand these 2 damages together. Ordinary damages are those damages caused by revocation of contract which are not warranted in advance. That means one party does not communicate to other party that any breach in contract will lead to damages or any delay in performance lead to damages. Such warrant or such caution is not given by either of the parties. Then any damage arising in normal course of performance is called ordinary damage. Second, special damages. Damages which are very much warranted in advance are called special damages. That means one party or either of the parties communicates that any revocation in contract or especially any delay in performance of contract leads to damages or losses. So they are intimated in advance. It is called special damages. Please do remember that both ordinary and special damages are pertaining to delay in performance of contracts, right? So ordinary damages are not recognized by the court, but special damages are recognized by the court as they are very much intimated by either of the parties in advance. Let us take two important case laws to illustrate the law on damages. Indeed, the entire law on damages that is defined in section 73 of Indian Contract Act is winnowed from the benchmark case Harley versus Baxendale. What happened in this case is Harley had one factory wherein one machine got broke down, and Baxendale was a service provider who repairs the machine. So Harley sent that machine to Baxendale for repairing purpose. Baxendale normally he said 3 days will be the time he consumes to repair the machine. Harley said okay, nothing else happened. But Baxendale could not give the machine fix the problem within 3 days. So he took some 5 or 6 days. That is not given in the case. So Harley sustained losses because of the delay caused in repairing the machine. So he filed suit for compensation. He said because of the delay caused in repairing the machine, he lost work orders in the factory. But court said no compensation can be given to Harley. Why? They are ordinary damages. You did not inform in the beginning that any delay caused in repairing the machine or fixing the problem will cause loss to you. So they are not intimated in advance, hence they are ordinary damages. Second case, special damages. Simpson versus London Northwest Railway Company. In this case, Simpson wanted to transfer some cargo in a railway wagon from London to Liverpool and exhibit that in a agriculture fair, so that he wanted to earn some money. He intimated at the time of booking the cargo very clearly that any delay caused in transportation will lead to loss and disables him from performing or participating in the agriculture exhibition. Normally, railways are known for causing delays. So, the rail did not reach on time to Liverpool. He could not participate in the agriculture fair. He sustained losses. He claimed compensation through legal action. Court said yes, you can claim because they are special damages very much informed in advance. Got it? Next, liquidated damages. Liquidated damages are one step ahead of the special damages. Here, the intimation with respect to loss sustained by delay is not only informed in advance, but the quantum of compensation to be paid is also intimated in advance. For example, government gives construction contract of an irrigation project to one company and clearly says the stipulated time period is 2 years under normal circumstances. If it is not completed in 2 years, so 10% of the cost of project will be collected as penalty, that is liquidated damage. If the delay is beyond 4 years, assume like this, the quantum of damages collected will be 15% of the cost of project. So you will not only inform about the loss sustained due to delay in performance, but you will also fix the quantum of damages to be compensated in very much advance. That is called liquidated damage, right? So ordinary damages are not at all recognized. Special damages are recognized. Liquidated damages are recognized as well as intimated in advance with respect to the payment to be made in terms of compensation if contract is revoked. Nominal damages. Nominal damages are those damages which are very, very negligible in quantity, right? For example, you have purchased 1 kg of atta of a very famous branded company, right? You all know that 1 kg consists of 1000 grams, and you have used your advanced electronic device and found that it has got only 999.9 grams. That is, it is less than 0.0001 gram to meet 1000 grams or 1 kg obligation. Can you file case to recover compensation for that 0.001 gram of lesser package or lesser weightage in the package? No, because it's very nominal, it's very negligible in nature. So they are not recognized by the court in order to award any compensation. Got the point? Of course, what is nominal damage differs from case to case. Suppose when I imported say 1000 tons of cargo, a raw wheat for example, so during loading or unloading process there may be some damage, some loss, say some 50 kgs to 100 kgs or 1 quintal to 2 quintal. It's acceptable sometimes. But when I bring 1 kg of wheat and I want to ensure even 0.001 gram of accuracy in 1 kg, it's not acceptable. So, what is nominal damage shall be decided by the court whenever dispute arises, isn't it? Next, remote damages. Remote damages are also known as indirect damages. These damages are not caused by revocation of contract. Rather, these damages are caused due to subsequent action or subsequent activity executed by the aggrieved party when contract is revoked. Confused? Let us take an example to illustrate it better. Let us suppose I am traveling in a train, right? So train has to reach the destination by 9 p.m. But due to some technical problems or due to signal issues, whatever it is, train is delayed beyond the scheduled time. Let us suppose it's 12 p.m. but still it did not reach the platform. But I can see the platform. I got down the train and I started walking to reach the platform because I can see the platform. 3 hours is passed, still the train is not reaching the platform. So while walking towards the platform, I got injured. I fell down and I got injured. It was late night, so I could not see something, some stones or some obstacles. I got injured. Now I went to court. It is because of the railway company which has caused delay in taking me to the platform or to the destination on time. So I became restive and I wanted to walk down from the train and I wanted to reach the platform on barefoot. So during which I sustained loss. Give me compensation. Will the court award any compensation to me? No, absolutely not. Why? Because it is your subsequent action. Had I been in the train sitting there for 3 hours continuously until it reached to platform, then I went to court for any loss, I would get some compensation. But it was my subsequent action, right? Unbeknownst to railways that I will do like that. So subsequent action that I undertook as a consequence of revocation of the contract, revocation of the promise made by railways. So it is called indirect damage. Who asked you to deboard the train and walk? To be frank, deboarding the train at a place other than designated by railways as platform is a punishable offense, isn't it? Unless there is a medical emergency or some accident taking place. So my action in this example is an indirect action that I undertook as a consequence of revocation of the contract by railways. So no compensation will be awarded to me. It's a indirect damage. Please remember. Of course, railway law is altogether different. Any delay will not attract any compensation in India now. That is different thing unless it's a cargo goods. But I am taking this example only to illustrate what the term remote damage exactly means. So don't attribute it to yourself whenever there is a delay in the passenger train, right? Railway laws are again different. I'm cautioning you. Next, vindictive damages. Vindictive damages are punishable damages, right? So if you cause a revocation in the contract in such a way that you will be subjected to imprisonment, that is the penalty you will get. That is called vindictive damage. Let us take an example. We all know from Negotiable Instruments Act, that is section 138 and 139 of Negotiable Instruments Act, that dishonoring of check or bouncing of check attracts 1 year imprisonment along with double the amount of penalty or both together, isn't it? So that is called vindictive damage. The damage which shall be awarded in terms of punishment to the party causing revocation of contract. It is called vindictive damage or punishable damage. Next we have damages for loss of reputation. You often read the news in papers, defamation suit, isn't it? So defamation suit is nothing but we file a suit in the court that someone's action has defamed your goodwill, has defamed your name or your company's name or your brand's name, whatever it is. So the quantum of compensation claimed in such cases would be very humongous. So for example, one newspaper has published a wrong news against me. I prove in the court that it is a wrong news. Then I file defamation suit against that newspaper agency. I may claim 20 crore rupees is the damage I sustained. So that is my discretion. I can claim any amount, but court will decide how much to grant as compensation. So damages for loss of reputation will be huge in terms of compensation that the aggrieved party can claim. Got the point? So these are various damages our law has recognized with respect to suit for damages as an eventual remedy for aggrieved parties. I repeat, ordinary damages are not intimated in advance, therefore they are invalid. They are not eligible for compensation as a remedy. Special damages are intimated in advance that they will occur if delay takes place in performance, so some compensation can be claimed as an eventual remedy. Liquidated damage not only intimates about the loss sustained due to delay in performance, but also prescribes the quantum of compensation to be paid at the very beginning of forming the agreement. That much amount we can claim as compensation, that is liquidated damage. Nominal damages are very notional damages. They are negligible in nature. Hence, courts will generally set aside this type of damages under the head eventual remedies in the case of breach of contract. Remote damages are indirect damages which are not recognized by the courts. These damages are caused due to the consequential actions of the aggrieved party when contract is revoked. Vindictive damages are punishable damages. The party causing revocation may be subjected to imprisonment. Damages for loss of reputation, which we famously call it as defamation suit, right? So ordinary damages, nominal damages and remote damages are not recognized as eventual remedies in the case of breach of contract. Now let us see other remedies a party can exercise whenever there is a breach of contract. The third damage which one can claim is suit for quantum merit. Don't worry, quantum merit is not an English word. Quantum merit stands for as much as earned. As much as you earned during the contract, that much you have to compensate me as a remedy because you have revoked the contract. That type of claim we can make by filing a suit in the court, right? I repeat, suit for quantum merit is a legal action taken by the aggrieved party to recover as much as the other party who is causing breach of contract has earned during the performance of contract, right? Suppose you worked for 3 months and then you revoked the contract. During these 3 months you have earned 20 lakhs rupees. That much amount you have to give me back. So that type of suit also we can file in the court. Courts will exercise their discretionary powers and the evidences will be examined to decide whether entire quantum merit can be awarded as compensation or otherwise. Suit for specific performance. Sometimes the revocation of contract may cause such damages which cannot be compensated in terms of money. In such circumstances, court may direct the party causing breach to perform the specific task instead of giving compensation, right? For example, the other party is causing a revocation of contract and I claimed, what is that you have done? You have revoked the contract. I sustained a loss. Then the other party may say, no problem. Tell me how much loss you sustained. I will compensate it. No. The loss you have caused is not to be compensated in terms of money. It's irreparable loss. Rather, performance of the contract or completion of the contract is the only remedy I can claim. So that type of claim also we can make by filing a suit in the court of law, right? Finally, suit for injunction. Injunction is stay order, right? Maintaining status quo, maintaining as it is status prevailing. Let me take an example. Suppose one middle class person has built a house. He took all the approvals from the municipal authorities. But suddenly when the process was there, the process was in progress, the construction process was in progress, the municipal authorities came forward and said, you have occupied 1 feet of the road, main road, and constructing the premises, our house. So we want to demolish it. The house owner say, no, I did not occupy your road. Please check the survey numbers properly. So there's a dispute. Meanwhile, if you demolish the construction, the house owner will sustain a loss. So what he will do? He will go and apply for injunction orders, stay orders. That means court will instruct municipal authorities in this example to maintain status quo. Don't demolish the construction until the dispute is settled, until we decide whether the house owner has occupied the road and constructed the premises. So unless and until this dispute is settled, you cannot demolish it. Once you demolish it and later it is proved in the court that it was not the fault of house owner, rather it was the fault of municipal authorities in finding the proper survey numbers. So that type of damages cannot be compensated. And moreover, that type of damages will cause huge emotional loss, emotional pain to the parties suffering loss. Therefore, courts will give injunction orders, stay orders. Stay order is maintain status quo, maintain the status as it is prevailing as of now. Then the court will decide who is at wrong, who is at fault in order to decide the remedies to aggrieved parties. Clear? So these are the various remedies available to aggrieved parties in the case of breach of contract. Friends, with this, part 1 of Indian Contract Act is completed, right? As far as the students who are pursuing their BCom in Osmania University, your entire first unit is completed in business law with this discussion. We started with introduction to law. We have discussed the essential elements of valid contracts, the classification of contracts, offer, acceptance, consideration, lawful object, capacity of the parties to contract, void agreements, contingent contracts, performance of contracts, discharge of contract, and finally we brought our discussion to fruition with this final chapter, that is remedies available to aggrieved parties in the case of breach of contract. So see you in the next series of video lectures with another set of topics or another subject. So for time being, please do attempt these assignment questions. The first assignment of the last chapter of first series: what are the remedies available to aggrieved parties in the case of breach of contract? Second question: write a note on law of damages. Please do remember, whenever you write any note on law of damages, you must scrupulously bring Hartley versus Baxendale and Simpson versus London Northwest Railway Company cases to discussion, because they are the benchmark cases based on which Section 73 of Indian Contract Act has been inserted into the law, right? That's all for now. If you have any queries, please revert back at 98495-60102 or nsureshnaidu@gmail.com. Not only for this chapter, for any previous chapters, please feel free to ask your queries. See you with a new series of video lectures shortly. Have a nice day. Bye.